All right, so here we are at the Newton Institute, and it turns out that Lord Kelvin has showed up to give a presentation. So Bill Thompson is going to be our last speaker today. Thank you for staying awake for his presentation. And he's going to talk. What he's going to ask us questions to help us stay awake. Right? What do experts need to know, and when do they need to know, and when do they know too much?
All right, yeah, that's the question. I think Kelvin spelled his name a little differently, but there is a quote from the great Lord that I really like, which is, it goes something like, knowledge that you can't quantify is of an inferior sort in the sciences. So I kind of agree with that. All right, when it comes to Bayesian nets, I'm a bit of a novice. I'm very much a novice compared to other people here. But I've been playing around with Bayesian nets, and I found them helpful in addressing these questions about what experts should know when. And so I thought I'd talk to you about what I've been doing with Bayesian net models in this area, and see if those in the audience who know more than I can help me with this problem. So what do experts need to know? This comes up particularly about, and to what do we not want experts to know? When should experts be blind? So you can state the question as being, what is relevant for an expert? That is, what should be considered and what's irrelevant, what shouldn't be considered. When it comes to relevance, we have rules for the trier of fact. Most jurisdictions have a rule that's like this one, the Federal Rule of Evidence 401 in the United States, which specify a broad standard of relevance. A fact is relevant if it's of consequence to determining the action, so any fact that has a tendency to make a fact more or less probable that would relate to the action is relevant. So this is very broad as a standard for relevance. It's probably the standard you'd want to apply if you hired an expert to make a decision for you. So if you want Sherlock Holmes to figure out what's going on in a case, you want Sherlock to have access to all facts that might change the probability of some underlying event. Even if you don't recognize the significance of what the dog did, Sherlock may recognize that the fact that the dog didn't bark means something very important, and as a result be able to draw a conclusion. So if we're talking about a trier of fact, decision maker, or an investigator who you are going to rely on to tell you what happened, you want them to know everything. Sherlock needs to know everything about the case. But the question that I want to raise is whether there should be different rules of relevance for experts who are not also the decision maker. So circumstances where the decision is being made by one person, say a jury, and the role of the expert is simply to feed information to the decision maker. Under those circumstances, there may be reasons to restrict what the expert knows. There may be grounds for different rules of evidence, and the question I'm going to raise is, what should those rules be, if there should be such rules? Now, questions about whether experts might know too much and whether that might be bad tend to be raised in circumstances where decision-making is distributed through a system of individuals. So this, for example, is you can think about the decision structure in clinical medicine. A patient comes into a doctor complaining of abdominal pain. And there's a primary physician who's going to be making the diagnosis and deciding a treatment plan. But the primary physician reaches out to other experts to provide information. Maybe a radiologist is going to do an x-ray, lab technicians might analyze tests, neurologists, other specialists might be brought in to consult, and they will feed information into the primary physician, who is the decision maker in this case, and we'll talk with the patient about a treatment plan. Okay, so in this situation, questions are often raised about how much these ancillary experts should know about the overall fact of the case. Starting in the 1960s and 70s, there was concern about a phenomena that was called at the time clinical information bias. There were findings that, so for example, if laboratory technicians who were interpreting echocardiograms, if they were told that the patient came in complaining of chest pains, so if they're told something about the diagnostic history, it made them more likely to, the same echocardiogram was more likely to be diagnosed or to be labeled abnormal. False positive rates went up. The arguments were made that this decreased the value of the expert evidence because the experts knew too much. This is a clinical information bias. But there's been a lot of debate in clinical medicine, particularly between radiologists and general practitioners in the United States, about how you determine what these ancillary experts should and shouldn't know. Okay? So this is one domain in which when you separate functions and when some experts are feeding information to others, what these experts should know and how much they should know about each other becomes an issue. So we observed similar facts. A few years ago, I got involved in some studies of the inference process in the United States, what's called WMD forensics, the process by which alleged terrorist episodes are investigated. So this is the decision structure if there's an allegation that a biological agent has been unauthorized release of a biological agent in the United States. So, an unusually high number of admissions to emergency room in Denver with people with their respiratory problems. Concerns are raised about whether they might have been exposed to anthrax, and about whether, if so, that was a natural event or an accident, or could the nation be under attack. These questions are funneled into these lettered agencies, the National Bioweapons something or other center, and so on. So there's a procedure in place for dealing with these incidents, but the procedure distributes the decision-making process among a lot of different agencies, many of whom have specialized roles. So there are academic roles who are prepared to do certain kinds of assays and answer certain kinds of questions, feed it into the centers. National labs have different capabilities. They feed information in. Commercial labs might be brought together. These labs are sort of area specialist labs. They feed information into a centralized integration facility where the experts are often called all-source experts because they're supposed to rely on a lot of different sources and put it together. With bioweapons, there's sort of a two levels of all-source. The NBFAC leads into this FBI unit, which leads to the laboratory and the DOJ, and there's a chain of command. But different people are inputting information into a complex decision-making process. In this area also, there's tremendous debate about how much the specialist experts around the periphery should know about the overall case. Should this academic lab who's analyzing a particular sample for a particular thing, should they know about what the other labs are finding on the same samples or different samples and so on? Or should that be left to the integrators? And the concerns come up about whether knowing too much can lead to bias. All right. Now, there's a decision structure in the justice system that's a lot like, I think, the clinical medicine one, that there's a trier of fact in the middle, which is a jury in some jurisdictions or a judge is in others. So we'll call this the trier of fact. The trier of fact is getting information from lay witnesses and possibly also from experts. And so, but questions can be raised about, should the experts know about the lay witnesses? How much should they know? When is that information about what the lay witnesses said, when is it relevant, useful information, and when is it potentially biasing? Okay? So what should they know and when? Certainly concerns about contextual bias have been very prominent in commentary on forensic science. Actually, from the 2009 National Academy of Sciences report, one of the major concerns is about experts being vulnerable to contextual bias that would render them vulnerable to erroneous identifications. There's discussion about the disciplines needing to develop rigorous protocols to guard against guide subjective interpretations and to protect experts from exposure to biasing information. But what do we mean? When is information biasing and when is it relevant? We don't, that's what we haven't really addressed very well. Contextual bias is said to occur when a forensic science judgments are influenced inappropriately by something irrelevant to their scientific conclusions. All right, and so this suggests that there could be a different rule of relevance here. There's certain things that would be relevant to the trier of fact would not be relevant to the scientific judgment, but the line where the line is drawn has been a little unclear. There's terminology for this. Some commentators have talked about information that is domain irrelevant. I actually prefer the term task irrelevant, but I think we need more specification, and the question that I'm trying to raise is whether there's a principled way to determine what's relevant for an expert for a particular task. Now, when it comes to what's relevant and irrelevant, you want to?
Is it at all a question of relevance, or is it a question of cost-benefit, whether its contribution to making the right decision is outweighed by the bias that it might create?
Okay. So yes, this is a good question, and I think my conclusion is going to be that we approach the question of whether it's relevant or not by asking whether it contributes to making a good decision. So I think I'm on the same track. But just to give you a sense of what the kinds of things that are viewed as being scientifically irrelevant, this is a well-known blood pattern analysis study conducted by Michael Taylor and colleagues in New Zealand. Blood pattern analysts purport to be able to look at spatter patterns like this and draw inferences about the activity that produced the pattern. But Taylor and colleagues found that their conclusions about the activities were influenced not just by the physical nature of the patterns, but also by information contained in the police report that accompanied the pattern. So if the police report mentions a witness statement about somebody hearing a gunshot, it was more likely to be seen as, quote, high-velocity spatter, or whereas if the witness statement instead mentioned something about somebody coughing, it was more likely to be treated as expiration. And so it appears that the putatively scientific conclusion coming from the expert is determined not entirely by the physical evidence, but is also influenced by something in the police report. And that, people say, well, gee, that doesn't sound like a proper scientific basis. These effects are strong. As psychologists would predict, these effects are stronger when less information is available because it's a smaller item, more ambiguous due to background, and so on. All right, and so you might say, well, the problem here is that blood pattern analysts are going outside of their domain. They're not considering just blood. They're considering, witness statements. They're outside of their domain. But there are other circumstances where we also see contextual bias, where the expert is staying in their domain. So here's two famous prints people will recognize as being from the Mayfield case. The one on the right is from the Madrid train bombing in 2004. One on the left from which was mistakenly linked to it, is from Brandon Mayfield, American lawyer. This is a high-profile latent print error, and in the postmortems on this, when people try to decide what went wrong, the conclusion from the reviewers, the Inspector General's report, and the other reviewers from the FBI lab said, well, what went wrong here is that there was a very ambiguous latent, and that while trying to interpret the feature, the latent, the analysts were looking directly at Mayfield's print, his reference print. And so where they found consistencies, they treated that as good data. Where they found inconsistencies, they endeavored to explain it away. Perhaps the plastic on which it was deposited had been wrinkled. Maybe there was distortion. Perhaps there was an overlay of another print. And so if it matched, it was good data. If it didn't match, it was bad data. And there's kind of this backward or circular reasoning that led to this latent being misinterpreted. Another form of contextual bias. But notice, it's from It's from the reference print. The expert didn't go outside the expert's domain, but the expert might have, in interpreting this ambiguous print, prematurely have been looking at this, right? So, and leading to bias. All right, and so there are a number of other studies that, if you're interested, there are lots of research. E.T.L. Dror has been a major figure in this area. Lots of interesting, clever studies in which it has been shown empirically that the conclusions of experts about forensic science evidence have been influenced by things that seem like they shouldn't have influenced it. But still, we don't have a clear delineation of what those things are. Now, the response to evidence of contextual bias has been to propose context management procedures, different ways of shielding the expert from potentially biasing information that the expert doesn't need. And this is a picture of an orchestra audition where and one of the findings in orchestra auditions is there was a strong gender bias, right? The males were much more likely to get into orchestras until in the 1980s they started doing auditions behind a screen, at which point the number of women selected for major orchestras in the United States went up fivefold. Okay. All right, so blinding procedures are used in many areas of science, and so one proposal is that we deal with contextual bias in forensic science by having a case manager who will screen out the evidence before it's given to an expert. And this works particularly well. This works particularly well if we're talking about an expert who's working at the bench comparing latent prints or comparing DNA profiles. I'm not sure. I don't think it works as well for Patricia, who's out in the field looking at pollen and so on. And but for some forensic science domains, you could have a case manager, somebody knowledgeable who decides what evidence needs to be examined, in what order, and then presents it to the expert, who's then blind to unnecessary contextual information. But still, we haven't defined exactly what's unnecessary yet. Another approach that deals more with the problem of the misinterpretation because of exposure to the reference profile is something called sequential unmasking. So you delay so information can sometimes be relevant, but you can delay exposing it until it's needed. So in the Mayfield case, you look at the analyst could have looked at the latent first and decided which to credit as good data and bad data before they were exposed to the reference print. They ultimately have to look at the reference print to compare it, but by delaying the exposure, you could reduce the risk of bias. So, and this raises the possibility that the evidence like the reference print is relevant for some tasks, not others. And this is why I like the term task relevant. We have to think about, is it relevant for what the forensic scientist is actually doing at the moment. So anyway, there are these context management procedures that have been proposed, and I've been very active in trying to encourage and promote these procedures in forensic labs in the United States. I've been chairing the Human Factors Committee of something we call the OSAC, and this has been a priority of ours to try to promote these procedures. But we face a lot of difficulty with forensic scientists pushing back against the notion of being blinded. And they make arguments like, well, what do you mean you're going to blind us to information? Isn't more information better than less? For a scientist, would you want your doctor to be blind?
Yes, it depends on the situation.
Yeah, I guess. I think the answer is it does depend on the situation. I think that. I think the error here, I think, is they're putting themselves in the position of the decision maker rather than the ancillary feeding information into the decision maker. So I don't think you want the decision maker to be blind, but forensic scientists, you're not the jury, you're not the judge, you're somebody providing information to the judge, and perhaps you don't need to know what everybody else knows. But but still, there are arguments. Would you put blinders on Sherlock Holmes? So I think there's a lot of the resistance to this arises out of confusion about what the proper role of the expert is in the legal process. But the arguments can be very powerful. And so I mean, I've heard this a number of times. You're saying it's contextual bias, but I feel it brings me closer to the truth. And if it brings me closer to the truth, how can it be a bias rather than being relevant? All right, but to illustrate, I mean, I think yeah, and so as I say, it raises questions about what the expert's role is. Forensic scientists in the U.S. seem to want to be Sherlock Holmes. I mean, there's a whole day devoted to the notion that forensic scientists are like Sherlock Holmes at this is at the American Academy of Forensic Science meeting a couple of years ago. It's kind of interesting. All right. What's wrong with this perspective? Here's a case that I think illustrates it well. Testimony from a bite mark expert explaining how he likes to know about the DNA evidence in the case. Right? So the bite mark expert is supposed to examine the bruises on the body and compare them to teeth to decide whether the bite mark might have been made by the person in question. Here's the statement of this expert. So he says, well, if I examined the marks and the teeth and I concluded that they were similar, but if I then, and they could have come from these teeth, if I then found DNA evidence came back, incriminating the same person, I might then upgrade my opinion from cannot exclude to probable. This expert.
They've been banned.
What's that?
That's why they've been banned. Yeah.
Well, yeah. This is an example, but I've heard the very same arguments from forensic scientists in other domains as well, right? So they want to know. They want to know, and they feel they can state a stronger opinion if they know that there's other evidence consistent with it. And so I think we need to articulate what's wrong with this. I mean, you have to ask the question: is the DNA result relevant? Certainly it's relevant to the jury. So, but why, as a matter of principle, why is this evidence that's relevant for the jury not relevant for this expert? And that's what I'm going to try to address, and I'll get to Bayes' nets in a minute, I promise. So one, I think one approach is to ask, not just is it relevant, but how is it relevant? And I think part of the difficulty with the experts relying on it is that there's kind of an element of backward reasoning here. So what is the logic that links the DNA evidence to the bite mark evidence, such that the expert becomes more confident about the bite mark in light of the DNA? It's something like this. I mean, the DNA matches the defendant. Therefore, the defendant must be the perpetrator, and if the defendant must be the perpetrator, then he's pretty likely the source of the bite mark. But notice, there's a certain backwardness to this logic. I mean, normally in science we draw inferences from data to a conclusion. Right here, the conclusion is being used to draw to interpret the data, and so there's this circularity or backwardness to it that's very troubling. There's also a strong potential when experts do this. There's a strong potential for double accounting of the evidence. So I was trying to explain this to forensic scientists. It's hard to get this. And this is an example I presented at an American Academy of Forensic Science meeting. Which was not well received. But I said, let's imagine we have three experts who are trying to determine the source of some item. We'll do two items being compared have the same source or different source. Expert number one, we'll call this the scientific expert, examines the sample, considers the likelihood of the observed similarities and differences, if there's a common source, if there's a not, and based on that, based on that draws a conclusion accordingly. So the expert is basically, the logic of commenting on the source is bottom up, from evidence to conclusion. All right, we'll call this scientific. Now let's imagine a different expert. This is a fake expert. Now this expert purports to be able to examine and compare the items on scientific grounds, but he actually doesn't even pay attention to the items. He simply considers all the other evidence in the case, and based on all the other evidence in the case, witnesses and so on, decides whether the samples that he's asked to compare are likely to come from the same person, and draws a conclusion accordingly. So his logic is top-down or backwards, from conclusion to the evidence. If all the other evidence suggests that these latent prints have the same source, I'll say it's the same source, you know. All right, so I think we have no trouble saying this guy is unscientific. In fact, if he claimed that he was presenting a scientific conclusion while drawing the conclusion in this way, we would call this fraudulent. This evidence, I mean, there's the entire conclusion that he's drawing is based upon other evidence in the case, which the jury likely will also hear. So there's no value added from the scientific evidence. Any weight that the jury gives to this evidence will in effect be double counting. So this is the incremental value, the value added here is 0. Okay? All right, so this is good, this is bad. But now let's say we have a third expert who takes a hybrid approach. And, you know, I think the great majority of experts in the United States who do forensic scientists do exactly this. You know, examines the evidence like expert 1, but also relies on other evidence like expert 2 to resolve uncertainty and determine how strongly to state conclusions. Maybe a little threshold shifting and so on. So it's an integration of this bottom-up reasoning with this backward top-down reasoning. So we'd say, you know, from my point of view, it's partly scientific, but partly not. Therefore, you know, arguably less valuable to the trier of fact. And I think the expert 2 is giving nothing of value to the trier of fact. Expert number 3 is like mixing an approach that has no value with an approach that has some value. It seems like it's diluting the value of the evidence. And so this kind of thinking led me into Bayesian nets because I thought, well, maybe in modeling this, we should start thinking about, we should start dealing with these questions by thinking about what is it that the expert's opinion or conclusion adds to the case from the point of view of the decision maker or the trier of fact. What is the incremental probative value of the expert's opinion? What the expert's opinion adds beyond what the expert already knows based upon the other evidence. And so I then started. This led me to start thinking about this in terms of conditional probabilities. So the basic model, let's assume a case where the issue for the trier of fact is whether the defendant's the perpetrator or not. And one piece of evidence that might support the defendant's a perpetrator is some piece of evidence found at the crime scene. So it could be a latent print found at the crime scene. So the secondary proposition, the proposition the expert is called in to evaluate is, was the defendant the source of the latent print at the crime scene? There's the expert examines the evidence, comparing the latent print and the defendant's prints, and notes the state of the evidence. They have similarities, and then based upon that, the expert derives and reports a conclusion. So the conclusion down here is R. The experts state conclusions in different ways. Sometimes it's categorical, sometimes it's a likelihood ratio. But we can ask, what is it that will maximize the probative value of the expert's conclusion? And what does the expert need to know to maximize the value of the conclusion for the trier of fact? And thinking about it that way, it suddenly becomes clear that what the expert needs to think about is the probability of E under these hypotheses, right? To do it scientifically. So any evidence that helps the expert assess probability of E under H and H, that seems like it ought to be relevant to the task when the task is evaluating scientific evidence. So that then starts giving us a criteria for relevance for an expert that's based upon conditional probabilities. So if it's relevant to probability of E under H, not H, it's task relevant for this task, okay? So thinking about it that way. And that's what the expert needs to know to maximize the probative value. Now, we can also use the Bayes nets to think about, well, what happens to the value of the expert's evidence if the expert is influenced by other information that may not be task relevant? Okay, so let's imagine let's imagine that that in this criminal case where the question is the defendant the perpetrator? There are two pieces of evidence. There's an eyewitness who says, "I saw him do it," and then there's a fingerprint found at the scene, which is processed by an expert. All right. Now, I think in the sort of the natural state of affairs, if the expert doesn't know anything about the eyewitness, then I think you'd model it like this. I mean, if the expert doesn't know anything about, if all the expert knows is, well, I have these prints to compare, and I'm asked, if all the expert knows is the state of the evidence, then there's no way the eyewitness could have influenced the expert. These are conditionally independent, separate things. All right, but what happens if, because the expert wants to be Sherlock Holmes and know all about the case, the expert knows about the eyewitness? The detective might mention, it might be in the police report that there's an eyewitness who said highly incriminating things. Then the expert's conclusion, we know from the drawer studies and others, might also be influenced by that. Okay, so how does that affect the value of the expert's evidence? Does that make the expert's evidence more or less valuable to the trier of fact? And I'll argue under most circumstances that you can model, it's likely to make it less valuable. I mean, generally, evidence, the collective value is more. The collective value of two pieces of evidence is higher when they're independent of each other than when there's a dependency. Just as a general principle, I sort of, from modeling this, I think that may not always be the case, but you can imagine circumstances where this dependency could increase the value of the expert's report, but those would be pretty unusual circumstances. But anyway, so what we need to think about then is in order to model this are the conditional probabilities of the expert reporting a particular conclusion conditioned on both the state of the evidence and the expert witness, and how the knowledge of the expert witness affects those conditionals. This allows us to think logically about the problem. All right. So I mean, one thing that I think is likely to happen, I mean, is like the bite mark expert knowing about the DNA, so that's what, I would have just said it's an inclusion, but I know the DNA is there, I'm going to say it's likely him, right? So it's sort of this shifting of threshold for reporting categorical conclusions. So I think it's likely if let's suppose we've got the latent print expert, let's suppose here are the conditional probabilities. The probability that the expert is going to report R, where let's say R is a report that indicates an association of the two prints, and let's say there's likely it's if the prints are from the same source and highly similar, I think it's likely that the expert will report it. So let's say that's 0.8, and let's say the probability of a report of association when they're from different people is 1 in 10,000, right? So that would, that if we assume that, you could choose your own numbers if you like. We've got a likelihood ratio of 8,000, indicating that's pretty strong evidence. What will happen if the expert now learns that an eyewitness also incriminated this person? I think likely the threshold will shift such that the expert is more likely to report R. R becomes more likely to be reported, both under H and NH. But the thing that's interesting is that the probability of R under H is already pretty high. There's not a lot of room to move up. I mean, you could go from 0.8 to 0.9. I mean, you could reduce the miss rate by half. But if you also actually this could be 2. If you cut cut the miss rate in half and increase the false positive rate by double that, you would cut the value of the evidence by a tremendous amount. Very quickly, even if it caused the expert to be certain to report a match, if it also increased the false positive rate even a little, it can degrade rather drastically the value of the evidence in ways that are kind of counterintuitive, right? I think it's hard for people to see that some tiny increase in the false positive rate could greatly diminish the value of the evidence, but it could. And so that's a cost of failure to blind the expert. Failing to blind the expert, allowing the expert to be influenced by task irrelevant information from the rest of the case, makes the evidence that the expert presents to the jury less valuable than it otherwise would be. Now, the model also shows, there's another really interesting thing that I realized as a result of modeling this, and that's that even though the value of the expert's conclusion, as measured by the likelihood ratio for the probability of H given R, even though that's diminishing as the expert considers the eyewitness, the probability that the expert's statement will correspond to so the probability the expert will be making the right decision could be going up, right? So and models will know how this has been true. And so there's this paradoxical thing that comes out of this. So I called it in one article a criminalist paradox. But so contextual bias may decrease the probative value of the expert's conclusion for the jury, while also increasing the probability that the expert's correct. And this is true. I mean, the expert becomes more likely to reach the right conclusion because the expert's no longer relying just on the latent print, but also on all the other evidence in the case. But that other evidence, of course, is going to be considered by the jury anyway. So the expert becomes more likely to be correct, but not because of the science, at the same time that the value of the expert's conclusion for the trier of fact is going down. So this is the paradox. The experts help themselves to reach the right conclusion while increasing the chance that the system as a whole is going to go wrong, right? And so this explains why the problem with the expert who say, well, gosh, how can it be a bias if it leads me to the truth? The bite mark expert says, how can it be biased for me to be influenced by DNA evidence if it helps me find the truth? Well, yeah, it's helping you find the truth, but it's undermining the value of your evidence for the person who has to make the decision. All right? And so I think this is sort of an underappreciated phenomena that I found really, really interesting. Okay, and so I wrote a little bit about it in the Australian Journal of Forensic Science. All of this has led to more efforts to formalize a definition for task relevance based upon the logic I've outlined here and specified using conditional probabilities. So I worked on, we have a National Commission on Forensic Science. I'm not on the commission, but I'm on a subcommittee that drafts documents for the commission. And so I drafted this document that the commission approved end of last year called Ensuring that Forensic Analysis is Based Upon Task-Relevant Information. So this is an attempt to create a policy statement guiding forensic scientists that will take into account the problem of contextual bias and will deal with the problem by specifying in a clear and rigorous way what experts should and should not be relying upon to make decisions. So here's what it says. Forensic scientists should rely solely on task-relevant information when performing forensic analyses, and there's an appendix that defines what is task-relevant using conditional probabilities, basically saying it's task-relevant if information is task-relevant if it affects the probability of the data the expert will observe under the hypotheses, under the propositions the expert's evaluating. So OSAC, the commission also said OSAC, which is the Organization of Scientific Area Committees, the standard-setting body for the United States, should specify what types of information are task-relevant for common forensic tasks, and forensic labs should take steps to avoid exposing analysts to task-irrelevant information through the use of context management procedures. Okay, the report makes it clear that what is task-relevant is going to depend in part on what proposition is being addressed, right? If the source level proposition, who's the source of this fingerprint or who's the source of this DNA sample, that limits the nature of the information that needs to be evaluated to that which is needed, for the particular assay in question. If it's an activity level proposition about what happened, then obviously a broader range of information may be relevant to assessing the relevant conditional probabilities, right? So you have to consider, you know, the level of the proposition in the hierarchy in deciding what's relevant and not relevant, okay? So, you know, so what is task relevant? We tried to say it conceptually this way. So information is task relevant if it's necessary from drawing conclusions about the propositions in question, whether they be source level or activity level, from the physical evidence that's been designated for examination through the correct application of an accepted analytic method by a qualified analyst. So that's the Commission's statement. Maybe we could improve on this, but I think it's at least a step. It's a step toward addressing these issues. The Commission gave in the Commission document the following is information examples of task irrelevant information for a latent print analyst. You know, the suspect's criminal history, the information the suspect confessed, implicated by other physical evidence, information that another latent print examiner found, you know, same print on a different night. That would all be task irrelevant because none of this information helps the analyst understand the probability of the observed similarity between a particular latent and the reference, you know, under the hypotheses. This is all information that may help you determine the probability that the underlying propositions are true, but not the conditional probability of the evidence the expert is called upon to evaluate under those propositions. So it's the fact that it affects the conditional probabilities that makes it task relevant. Okay, so now we've been trying to implement this. I think it works pretty well for bench level analysts who are doing routine analytic tasks such as comparing latent prints, comparing fingerprints, comparing handwriting, and so on. Difficulties arise in applying the criterion of task relevance in fields where the expert needs to take a broader view of what's going on, particularly out in the field. And we heard a great talk from Patricia Wilshire at the last meeting about her work in forensic botany and, you know, tracing pollen and so on. And so what is task relevant and not relevant there in a field where, you know, maybe a lot of abduction needs to be going on and forming hypotheses becomes, you know, so it's not clear that this applies so well in those fields. We've had lots of debate at the OSAC with the medical examiners over this issue. There are a lot of difficulties in the United States that have come up in court cases that have to do with the appropriate basis for a medical examiner's conclusion. It's a well-known case in Iowa last year in which infant was found dead, and the medical examiner did an autopsy and also examined police reports and concluded that the death was due to homicide. The jury convicted the mother of murder, but it later turned out, I mean, the examiner actually admitted that the conclusion that it was homicide rather than an accidental killing was based entirely, none of it was based on the autopsy, which was indeterminate on that point. It was based entirely on the medical examiner's interpretation of the other evidence in the case, such as witness statements and the mother's statements to the police, which the jury also heard. And, you know, the Iowa Supreme Court overturned the conviction on grounds that the medical examiner's conclusion, medical examiners shouldn't be given a putatively medical conclusion based on non-medical evidence. All right, that's a problem. But what should they be relying on? How can, you know, given that we expect medical examiners to rely on non-medical evidence in reaching some conclusions, such as what to put on the death certificate, how we negotiate this is an issue still to be determined. So anyway, time to stop. But I hope you found this interesting, and I hope you can give me some suggestions on how to do it better.
I need to defer to the organizers as to when we finish. What time is the scheduled finish?
It's supposed to finish at 5.
which is now.
Be unfair not to announce.
We should have
Should be
one,
allowed.
We might need to know, especially it's like, is there
will-
wine waiting
oh.
for us? No, if not, we can take more time.
There isn't wine. That's the problem.
Oh,
There's no wine.
no wine.
Okay, might as well
The
wine.
assumption is that everyone would want
Out
to
of
get
here.
wine, but
Right. There are a great number of hands up. Okay, Patricia first.
You're absolutely right. If it's two people, if the forensic scientists are at the bench and they're looking at fingerprints or DNA, they don't need contextual information at all. But if you've got, and if there's an investigative part, then you do need the contextual information very strongly. And also, sometimes you can help the case if two specialists refer. For example, I can look at my samples and say, this is a limestone area. The mineralogist will then actually can define the limestone area. So we can actually find bodies in the field much more easily if there's conference between the specialists.
Right.
So it's in our situation, it's really very complex. The people you really need to worry about in this context are forensic pathologists, because invariably they want to be Quincy. And they do take an awful lot on that they shouldn't.
Yeah, no, I think it's interesting. But clearly there's some information that in your area you don't need. You don't need the suspect's prior record or anything like that.
Eyewitness account, you don't want any of
Yeah,
that.
okay.
No.
So no, I think it would help if forensic scientists just tried to specify what is relevant to the task in different areas. And
so that's within your eye.
yeah.
I'm sorry if I'm not picking you in the order in which you put up your hands. Lots of people put up their hands at the same time. I'm going to go with Charles next.
Bill, you didn't address very much the form in which the conclusions are drawn, except actually on this last slide. Because as long as you allow examiners to express opinions on the probability of the hypotheses, you almost force them to rationally include other evidence as well. And so don't you think, and so do you expect that with the new documents that have come out now from the NCFS and PCAST that tell them to go towards likelihood ratios, in some sense, even though they still are allowed to do a match-non-match thing, it seems, we might move away from that because, I mean, it's just rational to take the other evidence into account if you're allowed to express an opinion on the issues at stake.
Yeah, no, you're absolutely right, and I agree with you. I think the United States is gradually edging in the direction of having experts report, conditional probabilities or likelihood ratio-like statements rather than source probabilities or identifications. There's a direct conflict between the desire of some to allow forensic scientists to state conclusions on the propositions, and the sense of others that they can't, that the information that they would need to take into account to do that is not information that they should be considering. So, I mean, I think we're.
Or will be the source of a large part, at least, of the problem.
You might be right. Yeah. I certainly don't think you can. I think you can't solve one part of the issue of what the expert should consider without taking into account how the expert is stating conclusions. I think that's a really good point.
Okay, Alicia.
So a couple of comments. In the Mayfield example, the contextual bias was even worse, right? I mean, they even found maps of Spain in the computer at home.
Yeah. So there may have been contamination. Yeah. It was unclear in the investigation how much the people who were comparing the prints knew about those other investigative facts. But certainly, right. So.
So that was one, and the other one.
It was his daughter's geography project for school. So the daughter, yeah, it was. So.
Going to Spain on a trip, on a scholarship, something or another. So they had a bunch of maps of Spain on the computer at home.
Yeah. So the daughter is now a U.S. Senate staffer working for Senator Wyden from Oregon, who is proposing legislation having to do with improving standards for forensic science
Yes.
in the United States.
She's
And
the
so,
best.
so I no, but it's one of those things that, you know, what goes around comes around. So what a surprise to find that someone named Sharia Mayfield is the lead staffer pushing this
Yeah, that was the other one.
this legislation that the FBI is so unhappy with.
That was the other one, that the wife was a Muslim. But my other comment is that in the OSAC, at least in some of the committees, my former subcommittee, which is TRACE, is moving in exactly the opposite direction. So they have this new standard for training hair examiners, and it says explicitly, you need to know everything about the case. So, you know, the more information you get, the better, so that you can better analyze your hair. And I'm like,
Yeah.
that is written. This is
I know,
going to
but it's
be
ridiculous.
ASTM, absolutely.
Right. No, so, but I think, you know, these things are now on collision course, right?
Yes,
So it's
absolutely.
completely inconsistent with what the National Commission has said, and so you know, we're going to have a major showdown very soon over these questions.
Yep.
So, you know, but I'm just hoping we have a principled analytic approach for saying what a reasonable answer would be.
I think we're going to stop there and look, but unless Bill is in a rush to leave, I'm sure you can ask him questions later. Is there any,
I'll be around.
are there any other things to do at the end of the conference? Any
Propose
other
a thanks to the
announcements?
organisers.
Well, thank the organizers.